Hi there, I'm James Dapachi, and this is Coffee and a Case Note. Team, today we're going to talk about the circumstances in which you can get an interlocutory injunction, which means that the court makes an order stopping someone from doing something before the end of the proceedings. Because normally, right, you commence proceedings on 1 January 2019, you have the final hearing in December 2020, you get judgment in May 2021, and it's May 2021 that what you're after actually happens if you win, right? So what happens if back in 1 January 2019, you want to stop the thing happening on 2 January 2019? You want it more or less immediately. Well, because it is between the start and the end of the litigation, it's in the interlocutory stage. It's before the end. So what you want is an interlocutory immediate injunction. You want it right then. When is the court going to do that? Today we're going to look at an example of when the court found it appropriate to do so. A court will find it appropriate to do so when the court forms the view that the person who wants the injunction, that the claim is very strong. Secondly, that the balance of convenience is met. And that's a term that is not easily defined precisely, but in essence, the court weighs up and says, right, is the wrong that this injunction, that this stop is going to cure, is it something that we need to take the big drastic step of a stop, or can we just pay it out in damages at the end? Can it just be a money payment at the end? Is it really so dramatic? Is it really so dramatic that the balance of convenience favours the making of the injunction right now? And in addition to that, the party who wants the injunction has to give an undertaking as to damages. That if the court says, right, because of that injunction, you've got to pay some money, you give an undertaking if you're applying to do that. So with that clumsy explanation of an interlocutory injunction, an injunction you want before the very end of the proceedings because you want it right now, we're going to look at a scenario where an injunction of this kind was granted. Right, we've got a few parties, and our defendant today, or the defendant parties today, agreed in a deed of settlement that they weren't going to make any disparaging comments about these other parties. And so they said, right, we promise, we enter into this deed, we're not going to make any disparaging comments about these other parties. And the nature of the disparaging comments that were being made related to an alleged breach of workplace safety legislation that sadly led to a death. And so the disparaging comments that were being made were to the effect of, I won't quite repeat the nature of the language, but it was attributing blame for these deaths to these other parties and doing it in inflammatory, incendiary language. And so a deed of settlement is entered where the person saying these things agreed not to say them anymore. What happens? The person who made that agreement started saying them again. And so our disappointed party, who didn't want these things being said, they sought an immediate injunction to stop this person saying these things today. So they commenced the proceedings. Remember, final hearing happens in a long, long time. They said, right, we've commenced. We want them right now. So what did they do? They gave that undertaking that they have to give, the undertaking as to damages. They had to argue that they had a strong claim. And the argument they made didn't take long to make. They said, look, we've got this agreement that he said he's not going to do this stuff. He's doing this stuff. And so we've got a strong claim. And the court was inclined to accept that. And they then had to argue, right, because of the nature of these comments being made, damages aren't enough. Can't be cured with money. This cure, the best way to right the wrong that has been done to us, is an immediate injunction. And what the court said was, well, yes, the case is strong. You know, there's the agreement saying I'm not going to do this stuff. There's evidence that the stuff is being done. Tick. The claim is sufficiently strong. Then there's the question about the balance of convenience, or are damages enough? And the answer to that was no, damages aren't enough. And so as a result of those two things, the interlocutory injunction was granted. That's a slightly shorter summary than that which normally accompanies decisions about immediate interlocutory injunctive relief. And so I hope it assisted you nonetheless. And I look forward to joining you again soon, wherever we may be, for another coffee and another case note. Cheers.